each of you agreeing to participate with us via Zoom. And we think that's probably the best way to hear cases and keep the workload going. Want to remind everyone that even though we're not in the courtroom, all the rules and procedures are applicable as if we were in the courtroom, which essentially means that the procedure we follow today will be each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time with Mr. Hibner, you'll receive that rebuttal time as well. Before we get started, I want to introduce our panel for today: Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case.
Julius T. Malone et al. Versus ASF Intermodal LLC.
And we will hear from the appellant.
Thank you, Your Honor, and good afternoon, Your Honors. Michael Petherick of the Chattanooga Bar here for the defendant and appellant in this matter. Now, as Your Honors are undoubtedly aware, this appeal arises out of a judgment that was entered in the Shelby County Circuit Court. It was entered after a multi-day jury trial that took place in front of the Honorable Judge Mary Wagner, and it started on September 9th, 2019. To be quite simple, my client admitted fault for the September 4th, 2015 collision to trial, and therefore the sole issues at trial were causation and damages. Now, the collision giving rise to this case, it took place between Mr. Julius Malone and Irvin Taylor, who is a former defendant, and it resulted in only around $7,000 of medical treatment. Now, at the trial, all the parties presented a substantial amount of expert testimony and lay testimony regarding the plaintiff's damages. And after the case was tried for several days, the jury deliberated for actually less than 2 hours. And despite the fact that Mr. Malone only incurred about $7,000 in past medical bills, they ultimately ended up returning a kind of startling verdict totaling $2.5 million. Only a little over $800,000 of that consisted of economic damages, and the remaining almost $1.7 million consisted of non-economic damages, including an award that, as I'll get into, we contend was a duplicative award of loss of consortium damages for Mrs. Malone. Now, with all that said, and all that background in place, it is my client's contention in this appeal, Your Honors, that the large verdict that was rendered by the jury in this case is not supported by the evidence that was presented at trial and instead resulted from speculation by the jury, particularly speculation as to future medical expenses and permanency of Mr. Malone's injuries. We additionally contend in this appeal that the large verdict resulted from passion and prejudice of the jury. Unfortunately, verdicts of this size are becoming increasingly more common in some areas of this country and tend to result from speculation and passion rather than the evidence that's been submitted, which is what we contend happened here. Now, and there are several reasons, Your Honor, why we contend that the jury's award of damages is not supported by adequate evidence. And the first of those reasons is that the awards of future medical expenses and the award of damages for permanent impairment are supported only by inadequate medical testimony in lay opinion, which is insufficient to support the verdict. The proof the plaintiff offered is insufficient because it doesn't comply with the requirements under Tennessee law. And under Tennessee law, an award of future medical expenses or of damages for permanency of injury can only be awarded if they are supported by adequate expert proof. And that proof has to be within a reasonable degree of medical certainty, and it has to be proof demonstrating that future medical expenses are reasonably likely to be required. And also, as to proof of permanency of injury, it has to reach that same level. It can't be speculative as to whether future medical expenses will be incurred, either as to the variety or as to the volume. Ultimately, it's supposed to assist the trier of fact with assessing damages. Now, With respect to the future medical or the testimony as to future medical treatment that was rendered in this case, we freely admit, I mean, the record reflects there is some testimony as to future medical treatment, particularly Dr. Rubin and Dr. Raimundi. They made some recommendations as to some examinations that will be required. But beyond those specific examinations, they solely testified that further treatment may be necessary. It may be necessary, it may not. Respectfully, that's speculative and is insufficient to support further medical treatment. Now, the plaintiffs attempted to bridge that gap with the testimony of a life care planner, and he did testify as to other treatment that may result. The plaintiffs tried to make up for the fact that that testimony was not rendered within a reasonable degree of medical certainty by claiming that it was within the scope of the practice of the life care planner, which we acknowledge, I guess that's it within the scope of his practice, but it's not within a reasonable degree of medical certainty. And the life care planner never claimed to render the testimony within that degree of certainty. Now, and the testimony about permanency of injury is perhaps even more speculative. I think it was Dr. Rubin, the record will reflect that he testified that brain injuries can be permanent. They can also not be permanent. And the plaintiffs had the opportunity to elicit that testimony, but respectfully, they did not. And it was upon that speculative testimony that the plaintiff's vocational expert also based his opinions, which calls into question the jury's award of damages for loss of earning capacity. Now, in addition to our arguments about the expert proof that was presented with respect to an award of future medical expenses and permanency of injury, there are also serious questions as to whether the damages that were awarded for loss of consortium were duplicative and therefore improper. Admittedly, the Tennessee law addressing claims for loss of consortium is somewhat sparse and vague. However, it does make clear that loss of consortium is a single claim that can be asserted by a spouse. It's composed of different elements. Loss of services is one, affection of the partner, that's another one, but ultimately it's a single claim. And the jury in this case awarded damages both for loss of services as well as for acts of love and affection. And respectfully, we contend that that was duplicative. It's a single claim. Loss of consortium is, it has separate elements, but that doesn't mean that there should be multiple awards of damages for loss of consortium.
Let me ask you, Mr. Patrick, by application of the cap, was the award for loss of consortium rendered meaningless?
I wouldn't necessarily say it was rendered meaningless, Your Honor. It was applied in the aggregate to the award of non-economic damages as a whole. So, I mean, if you look at it from the perspective of looking at percentages of reduction, I mean, it could be considered that by certain people, but as I said, it was applied in the aggregate to the award as a whole. Now, if that answers Your Honor's question.
Well, I'm just saying, going through the math without even adding the award for loss of consortium, wasn't that award not really viable for this plaintiff?
Well, Your Honor, I would contend since the caps were applied to the award as a whole that I mean, it could be considered to reduce them sort of pro rata since it was to the award as a whole.
Okay.
Yeah, now moving on to another.
Let me ask you a question about the loss of consortium claim as well. Were you provided the jury verdict form prior to it being submitted to the jury?
Your Honor, it is my understanding that it was. I'm appellate counsel, of course, and there is separate trial counsel. But to be perfectly candid with Your Honor, it was presented to defense trial counsel.
And was that jury verdict form objected to?
It was not, Your Honor.
And so why are we even discussing this?
Well, Your Honor, respectfully, I contend that Your Honors still have the discretion under Rule 13B to consider some of these issues, and we more of take issue with the verdict in general. It's less as to the verdict form.
And why would we want to do that if the counsel was presented with the jury verdict form, did not object at the time before it was submitted to the jury? Why would this court want to do that?
Yes, Your Honor. Well, because this is an important question of law. It's a question of law that there's not a whole lot of case law in, and it would be useful to.
There's a lot of jury waiver issues out there. In fact, I think there's several in this particular case.
Yes, Your Honor, and it's ultimately down to Your Honor's discretion. We contend that it's a point of law that would be useful to address. And just to summarize, Your Honors, I'll close my arguments here. We contend that the jury's verdict was not supported by the evidence. It was more likely resulting from passion and prejudice, and also two additional points. We contend that
Mr.
Sorry, Your Honor, I'll yield the ground.
Thank you. We'll hear from Appellee's counsel. You're muted, Mr. Llewellyn.
Thank you. I'm Eric Llewellyn for the plaintiffs Margaret and Julius Malone. The only issue raised in the defendant's motion for new trial was the sufficiency of the evidence to support the verdict. None of the other issues raised on appeal were raised in the motion for new trial. So the primary issue before the court, if not the only issue right now, is the sufficiency of the evidence to support the verdict. And so the standard of review is therefore pretty limited. The court's review should be limited to a search of the record for material evidence without any consideration as to the weight or preponderance of the evidence. That's from the Hohenberg brothers case. And in conducting that search for material evidence, the evidence supporting the verdict must be assumed to be true, and all countervailing evidence must be discarded. So with that standard in mind, the evidence at trial from Mr. Malone, his wife, their friends and family, was that Mr. Malone was a fully functioning adult who had been working warehouse jobs his entire adult life. Up until 2 months before this wreck, Mr. Malone was working at a warehouse in Memphis called J-Bill and was working 50 to 60 hours a week there. He was terminated from that job for reasons unrelated to his physical condition, took some time off. In August, began looking for new work, quickly found a job at the Sears warehouse, and was scheduled to begin work shortly after this wreck happened. Unfortunately, he was never able to start that job. Mr. Malone never had any problems walking or any cognitive or emotional problems prior to this wreck. That was uncontroverted at trial. This wreck happened on I-240 in Memphis. It involved Mr. Malone's vehicle being struck by 3 other vehicles traveling at highway speeds. One of the witnesses indicated that Mr. Malone's car looked like it'd been through Mario Kart. That same witness indicated that he was amazed that everybody, was walking away from that collision. Mr. Dukes, another individual involved in the collision, came up to Mr. Malone after the collision and said he was unable to understand him, and he saw Mr. Malone walking at the scene with a limp. There was testimony from 3 physicians for the plaintiff, Dr. Dalal, Dr. Rubin, and Dr. Ramundi. Dr. Dalal is an orthopedic physician. Dr. Rubin's a neurosurgeon. They both agreed that Mr. Malone has a bulging disc at L4, L5 that causes radicular complaints into his left thigh, which is consistent with Mr. Malone's complaints of pain. Dr. Ramundi is a neuropsychologist. Both she and Dr. Rubin testified that Mr. Malone had suffered a traumatic brain injury in this collision. Dr. Ramundi characterized the traumatic brain injury as, quote, drastic and severe, close quote. The The testimony from Mr. Malone's friends and family is that Mr. Malone tends to isolate himself now. He's subject to crying spells, all problems he never had before the collision. That is the material evidence to support the damages in this case and the jury's award. Mr. Malone has not returned to work since this collision, despite having a good work history his entire life. And that evidence supports the jury's award. As for the specific issue of future medical expenses that are raised by the defendant, contrary to the defendant's argument, each of the elements of future medical treatment that Mr. Zimmerman, our life care planner, spoke about was recommended by either Dr. Raimondi, Dr. Rubin, or was offered as a suggestion by him as part of his scope of practice as a nurse and registered nurse and athletic trainer. The majority of the future medical treatment was recommended by Dr. Rubin or Dr. Raimondi, including the frequency of that treatment. That's all in Mr. Zimmerman's testimony, that he relied on those recommendations. And we have detailed citations to the record where all of that testimony is. So
let me ask you, Mr. Llewellyn, at trial, was there any objections to Mr. Zimmerman's testimony concerning these costs?
There was not, nor was there any objection to Mr. Zimmerman's qualifications to opine on the areas that he offered his own opinion. There was also no motion for directed verdict on the issue of future medical expenses, and there was no objection to the jury verdict form, including a blank for future medical expenses. Given those lack of objections and the fact that Mr. Zimmerman testified he relied on the recommendations of Dr. Rubin and Dr. Raimondi as to the nature of the treatment needed and the frequency of the treatment in providing his life care plan, quite simply, the jury's award of future medical expenses is supported by evidence in the record, which again, this court must assume is true and discard all countervailing evidence. I think defense counsel acknowledged in his argument that there is some testimony as to future medical proof in the record. And given the standard of searching for any material evidence, that ends the analysis. As for permanent injury, the undisputed facts in the record are that there was an L4-5 disc bulge in Mr. Malone's back. Dr. Dalal and Dr. Rubin testified that was a result of this wreck. Dr. Dalal testified that Mr. Malone has restrictions on his ability to walk and stand. Again, Dr. Raimondi characterized the traumatic brain injury that Mr. Malone suffered as causing drastic and severe cognitive and emotional changes. Dr. Rubin and Dr. Raimondi offered recommendations to future medical treatment extending indefinitely into the future. And Mr. Malone and Mrs. Malone testified that Mr. Malone has never recovered from this. Their testimony was offered at trial 4 years after the subject collision. Assuming the truth of all of that testimony and drawing the reasonable inferences therefrom, there is material evidence to support a permanent injury. I will concede that the word permanent was not uttered by the physicians at trial, but we've cited testimony, both Barron versus State Department, a Tennessee Supreme Court opinion, indicating that medical evidence should be viewed in its entirety. We've cited authority suggesting that the court's role is not to look through the testimony of the physicians looking for magic words or magic language that could entrap somebody. The medical evidence is to be viewed in its total, and taking that whole picture, there's material evidence from which a jury could reasonably find that this was a permanent injury. A Sixth Circuit federal case, Lawrence versus DuPont, indicated that when reviewing a verdict affirmed by a trial judge, quote, the record in its entirety must be bereft of competent medical testimony to reverse a finding of permanent injury. This is not a record bereft of competent medical evidence. So for that reason, the jury's verdict on permanent injury should also be affirmed. Defendants have challenged the jury's award of loss of earning capacity for the same reason. The idea that there was no doctor uttered the word permanent to describe the injuries for the same reasons I just went through. There is evidence this was a permanent injury, and there was testimony from Dr. Strausser, a rehabilitation psychologist, that based on Mr. Malone's restrictions, particularly his inability to stand or walk for long periods of time, excluded him from the ability to perform the type of warehouse work that he had done his entire career. As a result, Dr. Strausser indicated he was permanently and totally disabled from working. And the jury accredited that testimony. There was some discussion of the loss of consortium, and for the reasons cited by Judge Stafford, that issue is waived and is not properly before this court. It wasn't raised at trial by an objection to the jury verdict form. It wasn't raised in defendant's motion for new trial. It was raised for the first time on appeal. And now under Tennessee Rule of Appellate Procedure 3E, under the holding in the state of Armstrong, issues should not be raised for the first time on appeal. Moreover, the authority cited by the defendants, the Swafford v. Chattanooga case, doesn't support their position. There's nothing in that opinion that suggests that loss of consortium damages be reduced to a single blank on the jury verdict form. In fact, the jury verdict form was prepared by defense counsel and plaintiff's counsel together, and the loss of consortium portion was derived directly from Tennessee Pattern Jury Instruction 14.20, which indicates that loss of consortium damages have multiple elements of damages, and lists the 4 of them. There were 2 that were applicable in this case: the loss of services of Mr. Malone and the loss of companionship and acts of love and affection of Mr. Malone. And the jury properly awarded separate damages for each of those elements of loss of consortium. So there's just nothing in Tennessee law that suggests that that award was duplicative or inappropriate. Defendant has suggested that the verdict was the result of passion, prejudice, or misconduct. First off, I would just deny the idea that counsel for the plaintiffs did anything to impassion or inflame the jury at trial. We did discuss themes of responsibility, but those themes of responsibility were also raised by defendant in their opening statement. In fact, one of the first things out of defense counsel's mouth was that ASF Intermodal took responsibility for this collision on day 1. They called Amanda Hall, their safety director, to testify of her efforts to settle Mr. and Mrs. Malone's property damage in an effort to establish that ASF was a good, responsible company who tried to take responsibility for this. That issue was injected into this case by the defendants, and plaintiffs were within their right to challenge that and to demonstrate that that was not, in fact, true. While we did talk about responsibility and accountability, we never suggested that the jury punish ASF Intermodal. There was never any discussion of punitive damages or anything like that. In fact, in opening and closing, counsel for plaintiffs explicitly asked the jury only to award damages for the full value of the damages that we established and nothing more. And that is, in fact, what the jury did. And moreover, the whole issue of whether we inflamed the passions or prejudice of the jury has been waived, because the portions of the opening statement, questioning, and closing arguments that defendants now object to were not objected to at trial. There was no objection raised to any of the statements of counsel referenced in their brief. Those issues were not raised in their motion for new trial and are accordingly waived. There are 2 other issues that the defendant raises, that the trial court erred in denying a request for continuance, and that the trial court erred in permitting the voluntary dismissal of Irvin Taylor. As for the continuance, that issue was not raised in defendant's motion for new trial and was therefore waived under Tennessee Rule of Appellate Procedure 3E. If the court wants to consider what Judge Wagner did on that issue, it must apply an abuse of discretion standard. And I submit that Judge Wagner's decision on the continuance was well-reasoned. It was not an abuse of discretion. It was not contrary to logic. She referenced that non-suits are a routine occurrence and that counsel have to be prepared to handle them. She referenced the financial resources and judicial resources expended at the time that the motion was made after a jury had already been impaneled. She referenced the court's willingness to slow walk the trial to provide defense counsel with additional time to prepare, including a 3-day weekend that occurred in the middle of the trial. And she mentioned that defense counsel who tried the case was intimately involved in all of the pretrial motions and, in fact, the entire pendency of the case, and therefore should be capable of trying the case. All of those factors that the court cited are reasonable, and there is no abuse of discretion on the issue of the continuance. As for the voluntary dismissal of Irvin Taylor, that's another issue that's waived. When Mr. Taylor was voluntarily dismissed from the action, there was no objection to the dismissal, and accordingly it was waived, and therefore it was also not raised in the motion for new trial and is being argued for the first time on appeal. The argument hinges on Rule 41.1's statement that voluntary dismissal of a quote action, close quote, can refer, defendant argues that it's limited to a single action, meaning the whole action has to be dismissed collectively. I submit that the plain language of the words that an action can refer to one cause of action against a single defendant. There's nothing in the rule that prohibits a single defendant from being non-suited. In fact, it's a common practice.
All right, thank you. We will hear from the appellant.
Sorry, Your Honor, had to unmute myself there.
No problem.
Just to address a few issues with respect to sufficiency of the evidence. I mean, we're contending just that, discarding all of the evidence offered by the defendants. We still contend that the evidence that was offered was insufficient, particularly in regard to the expert testimony for future medical expenses and permanent impairment. The plaintiffs had the opportunity to get that testimony. They examined their witnesses extensively, and they asked them about the future medical treatment that would be required. And their experts testified to some specific medical treatment that they thought was necessary within their degree of expertise. But then there's also other medical treatment that they did not actually testify to. And that's primarily what we take issue with. The verdict has to be supported in all elements. Now, as to the point that was related as to the objection to the qualifications of the life care planner, I respectfully assert that that's misconstruing what our argument is. We're not arguing necessarily that he was not qualified to testify to certain things. For instance, he testified as to what the market cost would be for the specific elements of treatment that Dr. Raimundi and Dr. Rubin actually testified to. With respect to the rest of them, though, the only testimony that's supporting that is his own, and it's testimony that's not rendered within a reasonable degree of medical certainty. And for that reason, we contend it's insufficient to support the award of medical expenses. Now, with respect to the permanency of injury arguments, we acknowledge there is no requirement that there are magic words to support an award of permanent impairment. I believe that's the term that was used in the appellee's brief. However, it does have to be reasonably certain within a reasonable degree of medical certainty. And respectfully, most of the expert testimony that was rendered with respect to that, some of it makes it even more confusing. If I'm not mistaken, when Dr. Rubin was asked about whether permanent brain injuries are permanent or not, he testified they could be, they could not. But then he didn't say whether this particular traumatic brain injury was permanent. So ultimately, it leaves it up to the jury to speculate. You know, this is a very scientific matter, which is the reason why you have to have medical expert testimony demonstrating it.
Was objection raised to that testimony at trial?
Your Honor, I don't believe that there was a specific objection lodged specifically as to that. I will say, though, that it was raised in arguments, particularly in the post-trial motion, that the doctors never actually testified that there was a permanent injury. And for those reasons, Your Honor, we contend that the award for permanency of injury, it's only supported by speculative medical testimony. Now, with respect to some additional arguments that were raised by Mr. Llewellyn with respect to loss of consortium, I rest on my arguments that I already articulated. It's a single claim. It should have a single award. With regard to the arguments regarding prejudice resulting at trial, Mr. Llewellyn states that that these arguments are waived, but as an initial matter, with respect to the actual cross-examination of the corporate representative of my client, trial counsel objected extensively to most of the questions that were asked. Ultimately, they were permitted, and that issue, the issue of whether the jury's award resulted from passion and prejudice, was also raised again in post-trial motion. So respectfully, we contend it's not waived. As to the other issues he claims are waived, we rest on our briefs in our arguments as to why they are not. Thank you, Your Honors, for your time.
Thank you, gentlemen. We appreciate your arguments. We'll take this matter under advisement and attempt to get you an opinion at the earliest possible date. We again appreciate you participating with us via Zoom. Mr. Hibner, anything we need to take up?
Your Honor.
All right, you may recess court until the call of the next case.
This honorable court is now recessed until 3 p.m.
Thank you, gentlemen.